Grand evening. I am Kanye Shobay. Welcome to class 3 of the beginner course for AMPAC, which stands for Allodium, Moorish, Praedium, Ante, Colorado. In class 3, we will be talking about the 1724 Christian Black Codes, as well as the 1855 and 1855 case with Dungey versus Joseph Spencer, and the 1857 case with Dred Scott. So let's get it going right now. Our good brother Brandon, our soon-to-be nationalized Moor, will start us off with the 1724 Christian Black Codes.
The Christian Black Codes of 1724 were initiated during Reconstruction after the Civil War to control blacks after they were emancipated. Passed by southern states, instead of giving blacks the same rights as white people, the codes limited the blacks' freedom severely. They included that blacks had to be in service of a white person, that they could not have congregations together, that they could not speak out, and that they could not have weapons. They also included that blacks could not go out without a white supervisor. Thus, blacks had to take on the religious and holidays and gods of their white superiors. These same black codes were said to have been made null and void with the ratification of the 13th Amendment in 1865. Although many southern states adopted black codes to keep former slaves from voting and imposed other restrictions. The 14th and 15th Amendments were supposedly had eliminated these codes. But as you read them down below and study the law of the land in conjunction with religion and politics, you'll discover these codes have been modernized in a disguise, and many are still in effect.
Yes. So one of the reasons why we can't take these codes out of effect is because they're using the main word as black. And when you use the main word as black, you're automatically putting us in a civil leader more two status. So also, our so-called black brothers and sisters were told that they could not read. So at the end of the day, how did they didn't know about these? Because they were told they couldn't read. And when you're told you couldn't read, how are you going to know something is happening? So our people still today, our so-called black people still today, don't understand that these codes are still in effect today. Article 1.
Article 1 decrees the expulsion of the Jews from the colony. Article 2 make it imperative on masters to impart religious instructions to their slaves.
Stop there. What are they still doing today? Everything is about religion. They're always constantly telling us when anything goes bad, just go pray about it, honey. Everything's going to be okay.
Put it in God's hands.
Religion, there's nothing wrong with religion, but it's the administrators that put the indoctrination into our brothers and sisters, into everyone's brain. Because remember, everybody is a Moor. The Europeans have Moorish blood in them also. Article
3.
Article 3.
Permits the exercise of the Roman Catholic's creed only. Every other mode of worship is prohibited.
Every other mode of worship is prohibited, but the Roman Catholic priests who burned the Moorish history must be prohibited. Article 4.
Article 4. Negroes placed under the direction or supervision of any other person than a Catholic are liable to confiscation.
Confiscation. You are liable to confiscation if you are not up under the supervision of a Roman Catholic priest. You are dead. Continue, my good brother.
Article 5. Sundays and holy days or holidays are to be strictly observed. All Negroes found at work on these days are to be confiscated.
What's happening today? Everybody's going to church. And what sporting event has took over church?
Football.
Football.
Yep.
The most powerful sport in the world has taken over church. Pastors and priests now having church at 8 o'clock in the morning so they can still get to their game at 11 o'clock in the day.
Yep.
Keep going.
Article 6. We forbid our white subjects of both sexes to marry with the blacks, under penalty of being fined and subjugated to some other arbitrary punishment. We forbid all curates, priests, or missionaries of our secular or regular clergy, and even our chaplains in our navy, to sanction such marriages. We also forbid all of our white subjects, and even our manumitted or freeborn blacks, to live in a state of concubinage with slaves. Should there be any issue from this kind of intercourse, it is our will that the person so offending and the master of the slave should pay each a fine of 300 levies. Should said issue be the result of concubinage of the master of the slave, said master shall not only pay the fine, but be deprived of the slave and of the children, who shall be adjudged to the hospital of the locality. And said slave shall be forever incapable of being set free. But shall this illicit intercourse have existed between a free black and his slave, when said slave, according to the forms described by the church, said slave shall become free and legitimate, and in such case there shall be no application of the penalties mentioned in the present article.
So right off the bat, forever incapable of being free. Then what they did, they mentioned, whenever you're having a white marriage and a black marriage, it is illicit intercourse. Vulgar. Unacceptable.
Downright wrong.
Right? Then it states in here, should said issue be the result of concubinage of the master, his slave, said master shall not only pay the fine, but be deprived of the slave and the children. So they're also penalizing the slave master also. They don't have any friends.
True.
If you tell these Moors who they are, we're going to penalize you too. So white people have no so-called white people have no rights, just like the so-called black people have no rights. It states it right here in Article 6.
Nope.
Article 7.
The ceremonies and forms prescribed by the ordinance of Blois and by the edict of 1691 for marriage shall be observed both with regard to free persons and slaves. But the consent of the father and mother of the slave is not necessary. That of the master shall be the only one required.
Continue.
Article 8. We forbid all curates to process to effect marriages between slaves without the proof of the consent of the master. We also forbid all masters to force their slaves into marriage against their wills.
Number 9.
Article 9. Children issued from the marriage of slaves shall follow the condition of their parents, and shall belong to the master of the wife, and not of the husband, if the husband and the wife have different masters.
Stop. The children belong to who?
The wife.
The wife. The woman is the most powerful human being on this earth. Midgard. There's nothing more powerful than a matriarchal woman. It states it right here. Article 10.
Article 10. If the husband be a slave and the wife a free woman, it is our will that their children, of whatever sex they be, shall share the condition of their mother, and be as free as she, notwithstanding the servitude of their father. And if the father be free and the mother a slave, then the children shall be slaves.
States it right again. The mother has the power. But with the indoctrination of the religion, i.e. the Bible, it states woman should be submissive. It states you must follow the husband. Here saying the woman has the power. Even if it's a slave, it still must follow the slave mother. This is too easy. Article 11.
Article 11. Masters shall have their Christian slaves buried in consecrated ground.
Article 12.
Article 12. We forbid slaves to carry offensive weapons or heavy sticks under the penalty of being whipped. and of having said weapons confiscated for the benefit of the person seizing the same. An exception is made in favor of those slaves who are hunting or are shooting for their masters, and who carry with them a written permission to that effect, or are being designated by some known mark or badge.
Stop. If you are a so-called black person, and if you're living in the state and they're saying that you can carry, but you up under the auspices of black, you still have broken the what? Law. It doesn't matter because you still black. But if you are a policy enforcer helping us, what is the policy? The brothers and sisters that are policy enforcers, they're not being put in jail for carrying because the law says, well, you're helping us, so you're good to go. But you must remember, you still got to go after your own people.
True. True.
Article 13.
We forbid slaves belonging to different masters to gather in crowds either by day or by night, under the pretext of a wedding or for any other cause, either at the dwelling or on the grounds of one of their masters or elsewhere, unless on the highways or in secluded places, under the penalty of corporal punishment.
Stop. What are we doing today? Clubs, nightclubs, bars. We forbid slaves belonging to different masters to gather in crowds. We are still gathering in crowds today. We are still breaking their so-called law because we're up under the auspices of black. We don't have any nationalities. There's not a black flag. There's not a white flag. You have broken the law. They can come right into the building and give you a ticket. You are breaking ordinance, codes, and statutes because we know it's not law. The real law and the supreme law of the land are the treaties. But you are breaking ordinance, codes, and statutes in our community because you're up under the auspices of black. Keep going, my good brother.
Which shall not be less than the whip. In case of frequent offenses of the kind, the offender shall be branded with the mark of the flower de luce, and should there be aggravating circumstances, capital punishment may be applied at the discretions of the judges. We command all of our subject, by they officials or not, to seize offenders, to arrest and conduct them to prison, although there should be not judgment against them.
You're still going to jail. Doesn't matter. There's no judgment against you, but we're still going to put you where? In prison. We haven't even put you into the pseudo court, but because you gathered in the crowd, we ain't gonna take you because you broke the 1724 Christian black codes, so you're going straight to jail. Our people today think that they're being picked on. Yeah, because you won't read. So they're gonna keep picking on you. And you want to keep calling yourself black, and you want to keep calling yourself white. They're going to pick on you all day.
All day.
Article 14.
Masters who shall be convicted of having permitted or tolerated such gatherings as aforesaid, composed of other slaves than their own, shall be sentenced individually to indemnify their neighbors for the damages occasion, thank you, by said gatherings, and to pay for the first time a fine of 30 levies and double that sum on the repetitions of the offense.
They have no friends. They have no friends. You think because you have the same prima facie as me, you're going to get penalized too. If you help these so-called black people, if you help these Moors, these unconscious Moors, we're going to get you too.
So you still get the slap on the hand nonetheless.
That's right. Don't matter that you got the same prima facie as me. They have no friends.
True.
There's no honor amongst thieves. Continue on.
True. Article 15. We forbid Negroes to sell any commodities, provisions, or products of any kind, without the written permission of their masters or without wearing their known marks or badges. And any persons purchasing from anything from Negroes in violation of this article shall be sentenced to pay a fine of 1,500 levies.
Always about the commerce, isn't it?
All the time.
It's constantly about commerce. People ask me, man, why is this ticket so high in Colorado when you get a ticket in Colorado? I say, because they let all the casinos go in the mountains. They don't make any money off of those casinos. They make all their money off of traffic, DMV, which is the fraud system, the fraudest system ever created.
Yeah.
Because the DMV has all your personal what? Information. They know how to find you.
Mm-hmm. They know where you live. They got your phone number. They got everything.
They capitulated this. They sat down at the table and went over this and over this. They work 7 days a week. We work 5 and think we did something.
Mm-hmm.
They've been having an extra 2 days on us for 250 plus years. It ain't built up.
2 steps ahead adds up.
Always. Continue on.
Articles 16, 17, 18, and 19 provide at length for the clothing of slaves and for their substance.
Article 20.
Slaves who shall not be properly fed, clad, and provided for by their masters may give information thereof to the Attorney General of the Superior Council or to all the officers of an inferior jurisdiction, and may put the written exposition of their wrongs into the hands, upon which information and even ex officio shall the information come from another quarter. The Attorney General shall prosecute said masters without charging any cost to the complainant. It is our will that the regulation be observed in all accusations for crimes or barbarous and inhumane treatment brought by slaves against their masters.
Now, here go to trickery. Let's not fall asleep once you read this. This is what our people do. See, they're not so mean. The slave gets to go tell the Attorney General on his master if he's not being treated right. Kanye, Shobey, what you're talking about. You Moors always saying that they're mean people. See? My master good to me. Look at this. This is trickery. To make you think your opinion matters, and your opinion does not matter one bit because you're still up under the auspices of black.
Nope.
Do not let Article 20 in the Christian Black Codes fool you. You have no rights. They're going to let you put it on the docket, tear it up, throw it in the back, and say, I don't know where I lost that piece of paper at.
That's exactly what they would do.
Article 21.
Slaves who are disabled from working, either by old age, disease, or otherwise, be the diseases incurable or no, shall be fed and provided for by their masters. And in case they should have been abandoned by said masters, said slave shall be adjudged to the nearest hospital, to which said master shall be obliged to pay 8 cents a day for the food and maintenance of each one of these slaves, and for the payment of this sum, said hospital shall have a lien on the plantation masters.
See, once again, making it seem like they're doing something for us. First of all, you're not doing anything for us because we own the soil. But we're in a psychosis. We're sick. We forgot who we were. But, oh yeah, and guess what, Kanye? He even gonna pay my hospital at the doctor. My hospital fee at the doctor. They put you in, they take you out. You out of the psychosis, they put you back in it on Article 20 and 21. They put you right back in the psychosis to make you think, no, they have our best interests. Grow up. This is too easy. This is called trickery. That's why we're reading it today.
Exactly.
Article 22.
We declare that slaves have no right to any kind of property, but that all that they require either by their own industry or by the ability of others, or by any other means or title whatever, shall be the full property of their masters, and the children of said slaves, their fathers, mothers, their kindred, or other relation, either free or slave, shall have no pretensions or claim thereto, either through testamentary, nor positions or donations inter vice? Vivus, thank you. Which dispositions and donations will declare null and void, and also whatever promise they may have entered into by persons incapable of disposing of any kind or participating to any contract.
Right now, your contract is null and void. That's all.
Mhm.
It's just null and void. You're a slave, and you're calling yourself black. The contract is null and void.
All right, you're making your property, and then you say that you're stateless, so now you just...
There's nothing we can do for you. Same thing like our brothers and sisters today. We can't help Negro, blacks, and colors. You have to help yourself. Article 6 of the 2010 Declaration of Rights to Indigenous People says everybody has a right to a nationality. 1948 Declaration of Human Rights 15.1 states every person born has a right to a nationality. 15.2 states no one shall be arbitrarily deprived of claiming their nationality at any point in time. They didn't say go claim nigger. They didn't say go claim black. They didn't say go claim white or hunky or redneck. They said go claim a flag, a nation, 195 of them. Which one do you want to claim? We need to grow up. Continue on, good brother.
Article 23. Masters shall be responsible for what their slaves have done by their command, and also for what transactions they have permitted their slaves to do in their shops. In the particular line of commerce with whom they were entrusted, and in case said slaves should have acted without order or authorization of their masters, said masters shall be responsible only for so much as has turned to their profit. And if said masters have not profited by the dining or transaction of their slaves, the per curiam, thank you, which the masters have permitted their slave to own, shall be subjected to all claims against said slaves after deduction made by the masters of what may be due to them. And if said per curiam should consist in whole or in part of merchandise in which the slaves have permission to traffic, the master shall only come in for their share in common with the other creditors.
Exactly, come in for their share. That's it. If I don't have a share, guess what? I'm gone.
Yeah.
I'm only coming to collect and I'm coming to leave. That's what they still do today.
True.
I'm coming to collect. I don't care if you having stress, duress, and coercion. I don't care if you don't have a job. I'm just here to collect. How you gonna collect when somebody don't have anything? They take your soul. They take your mental mindset. They put you in fear. See, when you don't give them the money, when you don't give them the Federal Reserve note, you're still in fear, aren't you? Yeah. So they've already taken your what? Your mind. Continue on, good brother.
Article 24. Slaves shall be incapable of all public functions and of being constituted agents for any other person than their own masters, with powers to manage or conduct any kind of trade. Nor can they serve as arbitrators or experts, nor shall they be called to give their testimony either to civil or in criminal cases, except when it shall be matter of necessity and only in default of white people. But in no case shall they be permitted to serve as witnesses either for or against their masters.
Hold on 1 second. Didn't it just say in Article 20 that we can tell the Attorney General and our opinion matters? Didn't it just say that in Article 20?
It did.
Okay, so then now in Article 24, it's just telling you your opinion doesn't matter. See the trickery again? Because they wanted you to stop at Article 20.
what it was.
You gotta keep reading and reading and reading. Prophet said, study, study, study. And when you think you studied enough, keep studying.
They try to get by saying, we treat our property just right.
That's right.
And it's like, oh yeah, you guys are totally right. But no, there's
I didn't say it. You didn't say it. AMPAC didn't say it. Who said it? They said it. They wrote it. They just never thought that we would what? We would read it. Continue on, good brother.
Article 25. Slaves shall never be parties to civil suits, either as plaintiffs or defendants, nor shall they be allowed to appear as complaints or in criminal cases. But their masters shall have the right to act for them in civil matters and in criminal ones, to demand punishment and reparation for such outrages and excesses as their slaves may have suffered from.
Hold on. They just said if your master not treating you right, go tell on him, and the master will get penalized. Now it's saying you don't have any opinion. Your master must speak for you. I'm not confused. Listen to what I said. I fully understand what they're doing. We got to wake up. Article 26.
Slaves may be prosecuted criminally without their masters being made parties to the trial, except they should be indicted as accomplices, and said slaves shall be tried at first by the judges of ordinary jurisdiction, if there be any, and on appeal by the superior council, with the same rules, formalities, and proceedings observed for the free person, save the exceptions mentioned hereafter.
Article 27 to 32 were not immediately available. Article 33, good brother.
Slaves who shall have made themselves liable to the penalty of the whip, the flour de luce brand, and ear cutting shall be tried in the last resort by the ordinary judges of the inferior court, and shall undergo the sentence passed upon them without there being an appeal to the superior council. In confirmation or reversal of judgment, notwithstanding the Article 26 of the present code, which shall be applicable only to those judgments in which the slave is sentenced to be hamstrung or to suffer death.
This is why our people are in so much fear, Brendan. They're in so much fear because all we spoke about us is capital punishment, death, hamstrung, hung. Then our grandparents' pass it on to our grandparents. Our grandparents pass the fear on to our parents. Our parents pass the fear on to us. And we never wanted to speak up. Our good brothers and sisters today know something is wrong, just like the so-called Europeans know something is wrong, but they're all in fear. They not only put us in fear as the copper-tone original people of this land, the indigenous, aboriginal people of the land, they put their own people in fear. That's why nobody's speaking up. That's why everybody's hiding in corners or living in their cozy little suburban neighborhoods, knowing the truth and won't speak upon it. Wrong answer. I'm a tatty teller. I'm going to tell it all. We are going to tell it all.
What's going to be done?
Next article, brother.
Article 34. Freed or born free Negroes who shall have afforded refuge in their houses to fugitive slaves shall be sentenced to pay the masters of said slaves the sum of 30 levies a day for every day during which they shall have concealed said fugitives. And all other free persons guilty of the same offense shall pay a fine of 10 levies a day, as aforesaid. And should the freed or freed-born Negroes not be able to pay the fines herein specified, they shall be reduced to the condition of the slaves and be sold as such. Should the price of the sale exceed the sum mentioned in the judgment, The surplus shall be delivered to the hospital.
Hospital. We're always going back to this hospital thing, aren't we? Because now they just attacked the slave master now in that article, letting him know, we're gonna hurt you with in the pocket. But you see how the hospital is always capitulated into something? Because the hospital makes you sign the death certificate, i.e. birth certificate.
Okay.
The hospital was the ones that put us in chattel property. They work in conjunction with the pseudo government. I need everybody checking boxes. I need these so-called Europeans that have nationalities checking white, and I need these so-called Moors who has a nationality checking black, so we can make them chattel property. The hospital is always into something. Mother takes her baby home, doesn't even know she's already put her baby in chattel property, severely de mortuis, dead in the eyes of the law, because she ain't checked the box. This is too easy. We have to wake up.
You got to.
Next, the brother.
Article 35. We permit our subjects in this colony who may have slaves concealed in any place whatever to have them sought after by such persons and in such ways as they deem proper, so to proceed themselves to such researches as they may think best.
36.
The slave who is sentenced to suffer death on the denunciation of his master shall, when that master is not in compliance to the crime, be appraised before his execution by 2 of the principal inhabitants of the locality, who shall be especially appointed by the judge, and the amount of said appraisement shall be paid to the master to raise this sum, and shall be collected by the persons invested with what authority?
With what authority? Who's ever invested, they shall receive commerce, finance. Once again, all about finance.
So that's what it always comes back to.
Always comes back to finance. 37.
We forbid all the officers of the superior councils and all our other officers of the justice in the colony to take any fees or receive any prerequisites in criminal suits against slaves, under the penalty in so doing of being dealt with as guilty of extortion.
Extortion. Because that means that they're not getting their cut.
You're cutting into their finances.
See, but they've been fighting for a long time. But people don't realize that the Europeans have been fighting. The colonizers are always fighting each other. Everybody talk about us fighting. They've been fighting each other longer than we've been fighting each other. They don't put theirs out in the open. They make sure when we kill each other, they make sure they go to the south side of Chicago, put the camera on, keep rolling it back and forth and back and forth.
And they'll play that for
They'll
weeks
keep
on
playing
end.
it for weeks on end. Why the colonizers are fighting each other with the pen. They're at war with each other with the pen right now. They can't stand each other, but they hate us more. So they'll keep shaking each other's hand just to make sure they don't put us back in our rightful position.
Exactly.
Continue on, good brother.
Article 38. We also forbid all of our subjects in this colony, whatever their condition or rank may be, to apply on their own private authority the racks of their slaves under any pretenses whatever, and to mutilate said slaves in any one of their limbs or in any part of their bodies, under the penalty of confiscation of said slave and master, so offending shall be liable to a criminal to put their slaves in irons and to have them whipped with rods or ropes.
Okay, so let's look here, masters. You need to keep them in place. So we need to cut limbs, put them in rods, put the steel plate around them, make them drag it around. You got to let them continue to know that you are the master. Now, people are going to watch this video and get upset. They don't know that we taught them, the Moors, taught them on how to keep the slave in line. the Europeans were our slaves first. So don't start getting upset when you start reading these articles. Because what you're reading is what we taught them on how to do to us. Continue on, good brother.
Article 39. We command our officers of justices in this colony to institute criminal process against masters and overseers who shall kill or mutilate their slaves, when in their power and under their supervision, and to punish said murder according to the atrocity of the circumstances, and in case the offenses shall be pardonable, 1. We permit them to pardon said masters and overseer without being necessary to obtain from us letters patent of pardon.
Article 40.
Slaves shall be held in law as movables, and as such they shall be part of the community of acquest between husband and wife. They shall be seized under mortgage whatever, and they shall be equally divided among the co-heirs, without omitting from any one of said heirs any claim founded on perciput or right of primogeniture, thank you, or dowry.
Article 40. Article 41 and 42 are entirely relative to judicial forms and proceedings. Article 43, good brother.
Husbands and wives shall not be seized or sold separately when belonging to the same master, and their children, whom under 14 years of age, shall not be separated from their parents, and such seizures and sales shall be null and void. The present article shall apply to voluntary souls.
Voluntary souls.
Thank you. And in such case, sales should take place in violation of the law, the seller shall be deprived of the slave he has illegally retained, and said slave shall be adjudged to the purchase without any additional. All right. Article 44.
Stop there.
Gotcha.
This is where we talk about sharecropping. They were sharecropping the slaves. But we taught them sharecropping first. And they come right back around and start sharecropping us. Which is like tithes and offerings. Let's speak about tithes and offerings before the church starts and tell you how much the church needs the money. And for that single mother that's sitting over there with them 3 babies and no daddy around, we're going to need your percentage too. Because the good Lord going sooner or later give it back to you. But go home with no milk money tonight. Article 44.
Slaves 14 years old and from this age up to 60 who are settled on lands and plantations and are at present working on them shall not be liable to seizure for debt, except for what may be due out of the purchase money agreed to be paid for them, unless said grounds or plantations should be distressed and seized and judicially sale of the real estate, without including the slaves of the aforesaid age who are part of said estate shall be deemed null and void.
Articles 45, 46, and 47, 48, and 49 are relative to certain formalities to be observed in judicial proceedings. Article 50.
Masters, when 25 years old, shall have the power to manumit their slaves either by testamentary dispositions or by acts of intervicice, but as there may be mercenary masters disposed to set a price on the liberation of their slaves, and thereas slaves with a view to acquire the necessary means to purchase their freedom may be tempted to commit theft or deeds of plunder, no mitter to set free his slaves without the obtaining from the superior council a decree of permission from that effect.
Stop. So you got a slave master. He wants to free his slave. The slave says, look, I'll pay you to free me. All the money you gave me, I'm going to pay it back to you to free me. But that slave, as bad as that slave master want to free him, he can't. He has to go to what?
Council.
Superior council. Continue on, good brother.
With remission shall be granted without cost when the motive for the setting free of said slave, as specified in the petition of the master, shall appear legitimate to the tribunal. All future acts for the emancipation of the slaves freed shall not be entitled to their freedom. They shall be taken away from their former master and confiscated for the benefit of the India Company.
India Company. Okay. 51.
However, should slaves be appointed by their masters tutors to their children, said slave shall be held and regarded as being set free to all intent and purposes.
52.
We declare that the acts for the enfranchisement of slaves, passed according to the forms above described, shall be equivalent to an act of naturalization, which said slaves are not born in our colony of Louisiana, and they shall enjoy all the rights and privileges inherent to our subjects born in our kingdoms, or any lord or colony under our dominion.
Any land or colony under our dominion. You see on how they speaking now? First of all, those dominions means land. This is ours.
Yep.
But because our people are calling themselves black, they're saying, no, we're going to take your dominions. We're in your kingdom. And we have all the privileges that we've inherited because you guys went into a psychosis and started checking boxes that you were black instead of saying that you were Moorish. Thank you. And then we're going to speak in the Christian black codes. And we're going to use words like kingdom and land and dominions. We're going to speak like you too. To let everybody know you've educated us.
Yep.
Continue on, good brother.
We declare, however, that all manumitted slaves and all freeborn Negroes are incapable of receiving donations, either by testamentary dispositions or by acts inter vivos from the whites.
When you see those it's quote unquote whites.
Oh, okay.
You see those say quote unquote whites.
Gotcha. Thank you. Said donation shall be null and void, and the objects of said donations shall be applied to the benefits of the nearest hospital.
What did they just mention again, Brendan?
The nearest hospital.
They just mentioned the hospital again. See, people think they're doing, man, I want to go to the hospital. Hey, wait.
Yep. Just
There's a church in the hospital, ain't it?
Everyone.
Okay. We need to grow up. 53.
We commend all manumitted slaves to show the profoundest respect to their former masters, to their widows and children, and any injury or insult offered by said manumitted slaves to their former masters. Their widows or children shall be punished with more severity than if it had been offered to any other person. We, however, declared them exempt from the discharge of all duties and services, and from payment of all the taxes or fees, or anything else in relation to their persons, or to their personal or real estate, either during the life or after the death of said slave.
You're not doing us any favors.
No.
We already are foreign nationals. We already should not be paying taxes. How do you pay taxes on your own land?
True. We grant manumitted slaves the same rights, privileges, and immunities which are enjoyed by freeborn persons. It is our pleasure that their merit in having acquired their freedom shall produce in their favor not only with regards to their persons, but also on their property, the same effects which our other subjects derive from the happy circumstances of having been born free. In the name of the King.
We already know we were free. We don't need you to state anything for us. This last statement is arrogance. This last statement is seeming like they're doing us a favor.
Mm-hmm.
And this is what our same people fall into today. Oh, I got a job interview. They're not doing you no favor. Oh, I got a raise. They're not doing you any favors.
Mm-hmm.
They gave you that raise because you maybe started to wake up at work and question things, and they said, whoa, 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 we're going to give you an extra $3 an hour.
Mm-hmm.
Can you just keep your mouth shut?
Just pulling you deeper into the hole.
And we capitulate. This is what we've been doing.
Mm-hmm.
So this is the 1724 Christian Black Codes. I would always suggest anybody at home, anybody can read this, whether you're European, whether you're Moor, whether you're conscious or unconscious, you need to read the 1724 Christian Black Codes.
Mm-hmm.
Now, let's follow this up. Everything that you just read, Brendan,
Mm-hmm.
is key. We're going to talk about two cases. It's not going to take us long. We're going to talk about the 1855 Dungey versus Joseph Spencer case.
Okay.
And then we're going to talk about the 1857 case with Dred Scott.
Okay.
These will tie into the Christian Black Codes. Because one Moor was calling himself a national, and the other Moor was calling himself a Negro. And you're going to see on how they handle these two cases.
Mm-hmm. Sounds good.
William Dungey and Joseph Spencer case, 1855. I'll let you start here. Among 10 original.
Yes, sir. Among 10 original Lincoln documents discovered last summer in the Dwight County Courthouse is a bond for cost in William Dungey versus Joseph Spencer. Written but not signed by Lincoln, it was part of an interesting slander case. Family disputes that degenerated into slanderous, name-calling feuds frequently appeared in antebellum Illinois circuit courts. Such cases reflected the intent of American slander law to safeguard an individual's good reputation in the community against petty character assassination. Abraham Lincoln realized the value of reputation and declared in his first printed political speech that every man is said to have his peculiar ambition. I have no other so great as to that of being truly esteemed of my fellow man. One unique slander case Lincoln argued at the Dwight County Circuit Court, Clinton, Illinois, in the May and October 1855 terms involved much more than a defamation of character and suggestion that Huck Finn's friend Jim might have reconsidered his plans to escape to freedom. I reckon at by 4 in the morning I'd slip in just before daylight and swim ashore and take to the woods on the Illinois side.
Now let's stop there. Lincoln was the lawyer in the case. He took the case for William Dungey versus his brother-in-law, Joseph Spencer. His own brother-in-law said, this is a Negro. And this Negro should not be living where we living against his own sister.
In August 1851, William Dungey, a dark-skinned young man of Portuguese descent, married Joseph Spencer's sister. A family quarrel ensued, which became so bitter that in January 1855, Spencer claimed throughout the community that his brother-in-law, Black Bill, was a Negro. Since 1819, Illinois law permits quasi-slavery and restricted the immigration of free blacks into the state. As other northern states passed personal liberty laws granting additional rights to free blacks, Illinois toughened its stance against them. In 1848, Illinois' Constitution required the General Assembly to pass such laws as will effectively prohibit free persons of color from immigrating to and settling in this state. Those prohibitions were passed as the Black Laws and went into force on February 12, 1853, the future emancipator's 44th birthday.
Stop. What is he called, Brandon?
The emancipators.
The emancipators. Let's pull something out. Can I see you have your Black Laws Dictionary on you? No. Okay. Don't even have to pull it out. But it mentioned it's called the Black what? Laws. How long has this Black Laws Dictionary been around?
Quite a long time.
Quite a long time. You see on how they tell on themselves? They think, oh, look, as Moors, we're making this up. We're not making it up. We just read it. They just told on themselves. So what we do is to come tell all of our unconscious people, who are whether you're so-called black or so-called white, hey, we got some truth to tell you. It's right here. Read it for yourself.
True.
Continue on, good brother.
William Dungey faced losing not only his reputation, but his marriage, property, and right to remain in Illinois. Section 10 of the 1853 law stated that every person who shall have 1/4 Negro blood shall be deemed a mulatto. William Dungey retained Abraham Lincoln to quash the possibility that he might be judged a Negro and therefore suffer the severe penalties under the 1853 Act.
Now, people don't realize about William Dungey. Abraham Lincoln. He grew up in Illinois, Charleston, Illinois. I did a little research on him just because I went to Eastern Illinois, which is in Charleston, Illinois. And Abraham Lincoln is even a more.
Abraham Africanus Lincoln.
Exactly. He's mulatto. He has 1/4 Moorish blood in him.
Yep.
Continue on.
Lincoln filed his declaration charging Joseph Spencer with slander on April 17, 1855, and sought $1,000 in damages. A game of legal chess occurred during the first hearing in May. Spencer's attorney, Clifton H. Moore, and Lawrence Weldon filed a demur to Lincoln's declaration, asserting that his charges were insufficient in law. Judge David Davis agreed that 2 of the Lincoln's 3 charges were faulty. The case was continued and Lincoln was allowed to amend the declaration. At the next term of court, October 1855, the case was argued before a jury. According to Lawrence Weldon, Lincoln's talents as a trial lawyer were evident in his argument for Dungey. Weldon stated that Lincoln questioned Spencer's character by demonstrating how Spencer went from house to house gabbing that Dungey was a nigger. Weldon emphasized that Lincoln's tone and pronunciation had a curious touch of the ludicrous, which instead of detracting seemed to add to the effect.
So this man, his own sister's husband, went door to door saying, this is a nigger. His own sister that he grew up with. There's no honor amongst thieves.
True.
The colonizers don't even care about their what? Own.
Yep.
Continue on, good brother.
Lincoln further undermined Spencer by using humor to persuade the jury that there was reasonable doubt regarding Dungey's race. Weldon recalled Lincoln's statements. My client is not a Negro. Though it is a crime to be a Negro, no crime to be born with a black skin. But my client is not a Negro. His skin may not be as white as ours, but I say he is not a Negro, though he may be a Moor. Mr. Lincoln interrupted Judge Davis, scarcely able to restrain a smile. You mean a Moor? Not Moor? Well, Your Honor, Moor, not C.H. Moore, replied Mr. Lincoln with a sweep of his long arm toward the table where Moore and I sat. I say my client may be a Moor, but he is not a Negro.
Now stop. you and put more on the table. The judge even acknowledged Moors.
Mm-hmm.
Now all of a sudden people today say, what are you talking about that Moorish stuff? That stuff ain't real. It's all in the dockets. It's all on file.
Mm-hmm.
Moors are real. You guys burned our history.
Yep.
That's what happened.
Mm-hmm.
You took nationality away from us, the colonizers did. Standing here, all of them knew what a Moor was.
True.
Go ahead.
Lincoln then demolished the defendant's witnesses' testimony. Moore and Weldon had secured several dispositions from residents in Gills County, Tennessee, the Dungey family home. These witnesses stated that they had personally known the family and that the white community had regarded the Dungeys as Negro or of mixed blood. Under cross-examination, Lincoln argued that the testimony was hearsay as the witnesses admitted none of them lived within 30 miles of the Dungey residence.
Trees.
On October 18, 1855, the jury returned a verdict of guilty and granted Dungey $600 in damages plus court cost of $137.50. Lincoln charged a $25 fee, which Lawrence Weldon considered minimal. To avoid an appeal to the Illinois Supreme Court, Lincoln persuaded Dungey to remit $400 of the judgment in return for the defendant releasing all errors which may exist in the court record. Under Illinois law, the defendant could not appeal the verdict, but could appeal only on errors of procedure or evidence. Lincoln had taught Joseph Spencer an expensive lesson in domestic relations. Another source speaks about William Dungey versus Joseph Spencer case. Although historians have used this case to show Lincoln's skill in the courtroom and his keen legal mind, which examined a little closer reveals something much more profound: the understanding of race in the 19th century. Dungey, who had a slightly darker complexion than others in the community, claimed that his family was Portuguese. A recent scholarship suggests that his quote from Lincoln reveals race as socially constructed. To Lincoln, regardless of Dungey's skin color, his Portuguese or Moorish heritage gave Dungey legal and social rights in the community, state, and the country.
In the country. So you have to realize that Dungey was able to live as a free person,
Mm-hmm.
free human being, not a slave, because he's not a slave.
Mm-hmm.
He's a Portuguese Moor.
Mm-hmm.
Claimed his nationality on paper. He never said he was a nigger and never called himself a Negro.
Mm-hmm.
Always put himself in proper status.
Yep.
Now, we're going to go to the Dred Scott case. Now, Dungey wins his case in 1855. Okay?
Okay.
Now, Dred Scott, this is just 2 years later. 2 years later, when everybody realized this, Dred Scott becomes a free slave. Supposedly a free slave. Let's read.
Dred Scott decision, formerly Dred Scott versus John F.A. Sanford, legal case in which the U.S. Supreme Court on March 6, 1857 ruled 7-2 that a slave, Dred Scott, who had resided in a free state and territory where slavery was prohibited, was not thereby entitled to his freedom, that African Americans were not and could never be citizens of the United States.
Brother, I want you to read that one more time, and I want you to read it loud so your brothers and sisters to hear.
That African Americans were not and could never be citizens of the United States.
Now, who came up with this term, this supposedly African American term in 1988, Jesse Jackson? They were using this term way when? So why are we giving Jesse some credit? And first of all, Jesse, we were here way before 88. They say Jesse came up with the term. But we were here way before 1988.
Yes, we were.
That they were trying to call us African Americans. Nothing towards Jesse. Not trying to go at Jesse's job. Not trying to go at him. But the whole point is, they're saying he came up with this term, lying on Jesse. They're using this term where? They were using this term
200 years ago.
Exactly. Okay.
And that the Missouri Compromise, which had declared free all territories west of the Mississippi and north of latitude 36 degrees 30, was unconstitutional. The decision added fuel to the sectional controversy and pushed the country closer to civil war. Among constitutional scholars, Scott versus Sanford is widely considered the worst decision ever rendered by the Supreme Court. It has been cited in particular as the most egregious example in the court's history of wrongly imposing a judicial solution on a political problem. A later Chief Justice, Charles Evan Hughes, famously characterized the decision as the court's great self-inflicted wound.
Self-inflicted. Go ahead.
Dred Scott was a slave who was owned by John Emerson of Missouri. In 1833, Emerson undertook a series of moves as part of his service in the U.S. military. He took Scott from Missouri, a slave state, to Illinois, a free state, and finally into the Wisconsin Territory, a free territory.
Okay, let's stop right there. In the Dungey, it's saying Illinois wasn't a free state.
True.
So now, they're saying here that Illinois became a free state.
Did that have to do with the Dungey case?
See? Dungey made some precedents, but the revolution would never be what? Televised. They didn't let anybody know he made president.
True. Very true.
Come on with it.
During this period, Scott met and married Harriet Robinson, who became part of the Emerson household. Emerson married in 1838, and in the early 1840s, he and his wife returned with the Scotts to Missouri, where Emerson died in 1843. Scott reportedly attempted to purchase his freedom from Emerson's widow, who refused the sale. In 1846, with the help of anti-slavery lawyers, Harriet and Dred Scott filed individual lawsuits for their freedom in Missouri State Court in St. Louis on the grounds that their residence in a free state and a free territory had freed them from the bonds of slavery. It was later agreed that only Dred's case would move forward. The decision in that case would apply to Harriet's case as well. Although the case was long thought to have been unusual, historians later demonstrated that several hundred suits for freedom were filed by or on the behalf of slaves in the decades before the Civil War. Scott v. Emerson took years to be resolved. In 1850, the state court declared Scott free, but the verdict was reversed in 1852 by the Missouri Supreme Court, which thereby invalidated Missouri's long-standing doctrine of once free, always free. Emerson's widow then left Missouri and gave control of her late husband's estate to her brother, John F.A. Sanford, a resident of New York State. His last name was later incorrectly spelled Sandford on court documents. Because Sanford was not subject in suit in Missouri, Scott's lawyers filed a suit against him in the U.S. District Federal Court, which found in Sanford's favor. The case eventually reached the U.S. Supreme Court, which announced its decision in March 1857, just 2 days after the inaugurations of President James Buchanan.
Now think about this. This brother must have been an unbelievable slave. They are fighting in straws to keep him around. You can't win a war without a Moor. We built their homes, raised their children. Look at the Kennedys. Even the Kennedys was raised by Moors inside of that White House.
True. Very true.
This thing has went on like almost 20 years. And they're still fighting.
Yep.
Because the woman is in charge. Even though the slave master died, the woman still has what? The power.
Yep.
The matriarchal power.
Mm-hmm.
She's not giving up her power. She's going back to get her slave.
Yep.
The decision.
Chief Justice Roger Brooke Taney's opinion for the court was arguably the worst he ever wrote. He ignored precedent, distorted history, imposed a rigid rather than a flexible construction on the Constitution, ignored specific grants of power in the Constitution, and tortured meanings out of other more obscured clauses.
Stop. How many times have we said they don't abide by their own what? Constitution.
Mm-hmm. And he did not go by the Constitution.
They don't even read it.
Yep.
That Constitution means nothing to them. The treaties mean nothing to them. All the treaties were signed as the supreme law of the land. They don't read the treaties. They don't abide by their own Constitution, the colonizers don't.
Mm-hmm.
Continue on, good brother.
His logic on the citizenship issue was perhaps the most convoluted. He admitted that African Americans could be citizens of a particular state and they might even be able to vote, as they in fact did in some states. But he argued that state citizenship had nothing to do with national citizenship and that African Americans could not sue in federal court because they could not be citizens of the United States.
So right there again. You just stated that we are not citizens of the United States. Whether we're African Americans, niggas, Negroes, we are not United States citizens.
Mm-hmm.
We're foreign nationals. We are standing on Maghreb.
The most extreme West.
The most extreme West. They're telling you that in the secret right here.
True.
They're telling you you're in Morocco, the empire.
Very true.
So how is he a United States citizen when he is standing on his own soil? Guy just said, there's no way they can be United States citizen. Let me speak in code to you guys. Why don't y'all wake up?
Mm-hmm.
Go ahead.
Scott's suit, therefore, should have been dismissed for lack of jurisdiction by the district court.
Jurisdiction. Lack of jurisdiction. They never had any jurisdiction over him, but he put jurisdiction on himself, Dred Scott did, because he kept calling himself, I'm a free Negro.
Mm-hmm.
They didn't have any jurisdiction over William Dungey 2 years ago, because William Dungey said, I ain't got nothing to do with this N-word.
Mm-hmm.
I am a Portuguese Moor.
Mm-hmm.
You have no jurisdiction over me. I can live where I want to live on my land. I'm Aboriginal Indigenous.
Mm-hmm.
1828, Webster's Dictionary of an American. The really true American, the noun, is us. Any person of Aboriginal or what? Copper tone.
Mm-hmm.
Keep going, brother.
On this point, however, Taney stood on shaky constitutional ground. If even one state considered an African American a citizen, then the Constitution required that all states and
by reference
also the federal government, and had to accord that person, quote unquote, all privileges and immunities of citizens in the several states, Article 4, Section 2, which include the right to sue in federal court. Furthermore, Article 3, which establishes the jurisdiction of the federal courts, does not mention national citizenship, but rather declares that quote unquote, the judicial power shall extend among other things, quote unquote, to controversies between citizens of different states, the so-called quote unquote diversity
jurisdiction. Go ahead.
Even with this weak argument, Taney could have been accused of nothing worse than faulty reasoning if he had stopped there. If Scott was not a U.S. citizen, he could not sue in federal court, and the case would therefore have been improvidentally granted. But Taney was determined to impose a judicial solution on the slavery controversy, although later courts would adopt the policy of deciding constitutional questions on the narrowest possible grounds. The pre-Civil War courts often decided all issues that could support their rulings. Thus, Taney continued holding that Scott had never been free and that Congress had in fact extended its authority in the Missouri Compromise because it had no power to forbid or abolish slavery in the territories.
Let's stop there. This is such a huge case because nobody wanted this to be on their docket.
Mm-hmm.
They said they already got one. Now, if they win this one, if we allow this to go free,
mm-hmm.
he went free because he claimed the nationality. But if we allow this one to go free up under artificial status, we don't want that on our docket. We can't have that on our docket.
Yeah. Because
all these so-called slaves were going to continue to come in and say, what? No, I'm free.
Mm-hmm.
They'll be in court every day.
Yep.
Continue on.
The Missouri Compromise, which had served as the accepted constitutional settlement for nearly 4 decades, thus fell. Even the doctrine of popular sovereignty, as articulated in the Kansas-Nebraska Act, 1854.
Let's stop there. What word did they use?
Sovereignty.
Oh, how long have they been using this word?
Quite a long time.
Sovereign state. Article 2, Section 2 of the Colorado Constitution talk about the sovereign people.
Mm-hmm.
Even though they have changed that constitution 154 times, at the end of the day, Article 2, Section 2 states sovereign people. But then they say the Moors are domestic terrorists and kind of call us the sovereign people. People that are free are sovereign. We have high status.
Yep.
Continue on, good brother.
Whereby the people of each federal territory would have the power to decide whether the territory would enter the Union as a free or a slave state. Lacked constitutional legitimacy, according to Taney. He thus avoided the principles of free soil, opposition to slavery in the territories and in newly admitted states, territorial sovereignty, and indeed every aspect of anti-slavery constitutional thought. Regarding the question of Scott's freedom, Taney held that Scott could not claim to be free on the basis of his residence in Illinois or Wisconsin. Whatever status Scott might have had while in a free state or territory, he argued, once he had returned to Missouri, his status depended entirely on local law, notwithstanding the doctrine of once free, always free.
Notwithstanding. Go ahead.
Taney would have been on reasonable, strong ground had he limited himself to upholding the district court's decision based on the idea that status was to be determined by the states. Alternatively, he could have held that Scott was not entitled to sue Sanford in federal court on the basis of diversity of jurisdiction, because Missouri did not allow even free African Americans to be citizens. But Taney outraged much of the North by asserting that African Americans could never be citizens of the United States. The framers, in his view, did not regard African Americans as being among the quote-unquote people, for whose benefit and protection the new government was founded, notwithstanding the perfectly general language of the Declaration of Independence.
Declaration of Independence. Go ahead.
Declaration of Independence and of the preamble to the Constitution. Two justices, John McLean of Ohio and Benjamin R. Curtis of Massachusetts, wrote devastating critiques on Taney's opinion. Curtis, in particular, undercut most of Taney's historical arguments, showing that African Americans had voted in a number of states at the founding, quote unquote, at the time of the ratification of the Articles of Confederation.
Let's read that. All free native-born inhabitants of the states of New Hampshire, Massachusetts, New York, New Jersey, and North Carolina, though descended from African slaves, were not only citizens of those states, but such of them has had the other necessary qualifications possessed, the franchise of electors on equal terms with other citizens.
Thus, Curtis argued they were members of the nation and could not now be denied the right to claim citizenship.
But we're already members of our nation. This is our nation. We don't need your citizenship. We're standing on far northwest Madrid. You're acting like you're doing us a favor.
True.
You're not doing us any favors at all. But Dred Scott was in the mindset of Negro. Reception and significance. Go ahead, brother.
Quote unquote, the Southern opinion upon the subject of Southern slavery trumpeted one Georgia newspaper, quote unquote, is now the supreme law of the land, and opposition of it is, quote unquote, morally treason against the government.
What is the supreme law of the land?
The treaties.
The treaties. He ain't talking about treaties.
No, he's not.
So what is he talking about? Continue on, good brother.
The view that Southern ideologies such as John C. Calhoun had prompted for more than a decade that the federal government had a positive, indeed a constitutional, obligation to defend slavery had apparently triumphed.
Well, you're talking about, yeah, they got an obligation. From what treaty? 1787 Peace and Friendship Treaty between the United States of America and Morocco. See, they're trying to speak to you in code. They have an obligation to defend slavery. From the supreme law of the land. But he didn't mention what? Treaties.
Not surprisingly, the North exploded in denunciations of Taney's opinion. Several sober appraisals in the Northern press decimated the Chief Justice's tortured legal reasoning. The Republican editor, Horace Greeley, published Justice Curtis's dissent as a pamphlet to be used in the elections of 1858 and 1860. The press and pulpit echoed with attacks on the decision that were as heated as Southern defenses of it. Taney's hopes of settling the issue lay smashed. If anything, Scott v. Sanford inflamed passions and brought the Union even closer to dissolving. For all practical purposes, Northern courts and politicians rejected Scott v. Sanford as binding. In an advisory opinion, Maine's High Court declared that African Americans could vote in both state and federal elections. The Ohio Supreme Court ruled that any slave coming into the state with the master's consent, even as sojourner, became free and could not be re-enslaved upon returning to a slave state. The New York Court of Appeals handed down a similar ruling in Lemon
versus the People,
1860. In several states, legislators resolved to prohibit slavery in any form from crossing onto their soil and enacted legislation freeing slaves passing within their borders. Taney is remembered now almost solely for the blatantly pro-slavery decision he wrote and for his demeaning comments about African Americans. And when he died in 1864, he was roundly denounced and vilified in the North. Republican Senator Charles Sumner of Massachusetts predicted that, quote unquote, the name of Taney is too good to be rooted down the page of history. Whatever else he may have done, his name will always be linked with that of a slave who wanted nothing more than his freedom. Dred Scott did in fact get his freedom, but not through the courts. After he and his wife were later bought by the Blow family, who had sold Scott to Emerson in the first place, they were freed in 1857. Scott died of tuberculosis in St. Louis the following year. Harriet Scott lived until June 1876, long enough to see the Civil War and the 13th Amendment abolish slavery in the United States.
But then, look at your dates. In 1870, the Naturalization Act. Okay, so you guys abolished slavery in 1865. Then in 1870, the Naturalization Act come, which denationalized everybody. Abolish it, but then put you right back in the status of black, African American, and Negro.
Yeah.
He was never free. Dred Scott was never free at all. Look at all what he had to go through. That don't seem like a free person to me. He died, and his wife had to stay around stayed around for another 19 years after her husband died. What do you think he died of? Stress, duress, and coercion.
Yeah. All that'll do it to you. Weaken his system.
He was never free.
No, he wasn't.
He did not walk away like Dungey did. They put him up under stress, duress, and coercion. And then at the end of this paragraph, trying to make it seem like you did some good. Once again, always trying to make themselves seem like they're not the colonizing people that they are. A colonizer is always in disguise. And that's why Taj says, don't worry about the European, but you must keep a what? You must keep an eye on them.
Very true. That's a very good point.
So in our class today, we talked about the 1724 Christian Black Codes, which fell right into these court cases. 1855, William Dungey, I'm a Portuguese Moor. You're free to stay in your house with your woman, with your wife. 1857, Dred Scott, I'm a free Negro. No, you're coming with us. They chased him nearly 20 years. Stress, duress, and coercion up under the status of what? Black,
Colored Negro.
Colored Negro, free on your land as being a national Portuguese Moor. Hope this class was very beneficial for you today, my good brother.
It was.
We're almost at the first 5, but we're going to keep going and keep going and keep going. But this is a great read for all our Moorish brothers and sisters to understand. You got to read the Christian Black Codes. It will wake you up. And also, you have to study law and history. History and law goes together.